I strongly believe that dialogue has the capacity to resolve any conflict. I'm Shona Crallan. I'm a solicitor with a background in human rights law, and I'm a CEDR Accredited mediator. When I take on a new mediation, I want to understand the people involved, their concerns, the underlying issues, and the personalities. I'm detail orientated, so I will carefully review the case papers to ensure that I fully understand the facts and the figures of the dispute. My breadth of legal career, focusing on corporate law initially at Freshfields, intellectual property law at the London Organising Committee for the Olympic and Paralympic Games, and then specialising in human rights law at Hickman and Rose and the charity Inquest, means that what I bring to my mediation practice is a familiarity and an understanding of corporations, public bodies, and individuals. It has allowed me to develop a mediation practice where I mediate a range of disputes across civil and commercial matters. I believe that dialogue has the capacity to resolve any conflict. That is not to say that it's easy, and that's why the structured, facilitated process that mediation provides can often be required. I really enjoy designing the mediation process to fit the needs of the parties that I'm working with. I mediate in person and online, and I work with clients across the country and internationally. Throughout a mediation, I will ask the parties two questions. What does a resolution need to look like for you? And also, what do you think the other side wants? Putting yourselves in the shoes of the other side is a useful exercise to anticipate what they need so that you can best frame your offers and your negotiations in such a way as to more likely elicit agreement. William Ury, in his book Possible: How to Survive and Thrive in an Age of Conflict, describes an approach he uses called the victory speech. He asks parties to imagine they have settled on terms favourable to them and to then write the victory speech for the other side. We all have constituents of one form or another, whether that be shareholders, fellow directors, family members, in the case of public bodies, the public. Anticipating what the other side would need to say in order to sell any agreement as a success to their constituents will assist you in both determining what offers to make and how to frame those offers. You are more likely to reach an agreed settlement if both sides can sell that as a win to their constituents. Mediation is unique as a form of dispute resolution in that the power rests back with the parties, both whether to settle and what the content of any settlement agreement will look like. This can include considerations not available to a judge, such as ongoing relationships, commercial considerations, and personal considerations. Mediation is, at its core, a balancing exercise, comparing what could be achieved through a negotiated settlement at mediation versus what could be achieved in your best case alternative. That would often be going to court, particularly in civil and commercial, or perhaps tribunal in a workplace employment matter. So, working with the mediator, that requires careful consideration of both of those alternatives, looking at the litigation risk, the legal fees, the time and the emotional impact of a prolonged period of conflict, comparing that carefully against the benefits and the negatives of what's on the table on the day of the mediation in terms of possible resolution. There's a misconception that mediation necessitates compromise. I'm working with parties to see whether or not, when taking into account all of these considerations, there is a preferable option on the table today as a mediated settlement than what can be achieved in the best case alternative. I'm uncomfortable with the terminology of winning and losing in mediation, insofar as a win is presumed to mean a loss for the other side. But in this circumstance, if there is a preferable option, that is a win for this party. And because mediation requires agreement by both sides, if there is a settlement which is preferable for both sides of the dispute, then rather than that being a compromise, that is really a win-win. As a mediator, it's really important to appreciate all of the issues at play in a dispute, both those stated in the case papers and those not stated, the underlying issues. There was a case that demonstrated this for me. I was mediating a multi-million-pound dispute between founding directors of an international retail company. And when I was reviewing the case papers, I saw that one party was referred to by his surname and the other parties were referred to by their first name. Through direct conversations and exploring this with the parties, I discovered that there was significant cultural and status considerations between these individuals. And that knowledge allowed me to understand the business deals that had led to the dispute. And without this knowledge, I wouldn't have fully understood the possible routes to resolution. Joint sessions are a very useful part of the mediation day. I always say to parties that I manage the process, but I'm led by them. So I will advise on process aspects, including when I might think a joint session is useful. But I'll never push parties into having a joint session or a particular approach if they're uncomfortable in doing so. It's ultimately unproductive for parties to have discussions that they don't feel comfortable having. But I will explore with them what their reticence is and explain my reasons why I think it might be useful to see whether or not their concerns can be alleviated. Plenary sessions are nearly always helpful at the beginning of a mediation. And that's because there's something, I think, just human nature in being able to say hello and introduce yourselves to the people you're going to spend the rest of the day with in mediation, even if the rest of the day is in private session. It's also useful, I think, to say something about the intended approach that you will take to the mediation. There can be a skepticism at the beginning of a mediation, and just hearing directly from the other side sets the tone very well for the discussions and the negotiations to come. I don't think it's useful at this early stage to simply rehash what's already in the position statements or to use it as a rehearsal for opening statements in trial, but rather as a way to, as I say, set the tone for the discussions to come throughout the day. I do think it can be useful at points to have joint sessions where parties can have direct, sometimes very challenging and difficult conversations between them. Conflict inevitably involves emotions, and it can involve heightened tensions. And I think it's important that parties know that I won't prevent those sort of conversations taking place, and that I'm not concerned about that level of emotion being on display. Sometimes there can be a cathartic nature in getting something off one's chest that isn't necessarily a negotiation technique, but nonetheless it can be useful to shift something so that the negotiations that come after can be more productive. It's also important to keep coming back to the foundation of mediation, which is that I don't act as judge or arbiter. I am there to facilitate discussions between the parties to see whether there's an agreement that they want to reach. So I'm not directing or controlling the conversations, but I'm there to manage the process. And that's another reason why I think being open to joint sessions is a really useful approach in mediation. As a mediator, it's really useful to establish with parties at the outset of a mediation the broad parameters of what a resolution would need to look like for them, to consider what their interests are. Mediations inevitably involve difficult conversations and can involve heightened emotions and tensions. And so being able to come back to this question can be a really useful exercise. There was a case that exemplified this for me. It was a dispute in relation to a bridging loan. And halfway through the mediation, evidence came to light that showed that the defendant had committed fraud. He had lied about it in the pleadings and on the mediation day itself. This inevitably caused upset and anger on the part of the claimant, who contemplated walking out of the mediation. I saw my role in that moment as holding the space to ensure that any decisions made in that moment wouldn't be regretted the next day, so that if the mediation was to come to a close, it would be in a considered way. So I came back to this question with the claimant as to what their interests were and what they had wanted at the beginning of the mediation day. And what became clear through discussing with them was that their reasons for wanting a resolution at the outset not only remained, but in fact had been strengthened. So they had discussed a concern around reputational damage, and having any ongoing relationship now with somebody who had proven themselves to be untrustworthy increased that concern. They had mounting legal costs. The legal fees were only going to increase to court. And they had a frustration that there was time and energy being spent on this litigation that they wanted to focus on their business interests. So to the credit of this client and his lawyer, they recalibrated, they came back to the table, and they placed once more their initial offer on the table. The defendant now, with the evidence that had come to light, had little choice but to agree. And so they were able to conclude the day with a settlement and draw a line under the matter. The nature of human rights disputes is that there is a personal impact. And so conversation and consideration of these issues is something that mediation can provide. And I think mediation is particularly well suited in these claims to assist with trying to find a resolution. And consideration of early stage mediation is also particularly apt for human rights claims. What I saw when acting for claimants bringing human rights claims against the state was that years of litigation could exacerbate the distress caused by the breaches of their human rights. The opportunity to have these claims recognised and acknowledged at an earlier stage, and for resolution to be considered at an earlier stage, is valuable for all parties in these claims. There is a reticence often on the part of public bodies and governments to acknowledge and apologise, for understandable reasons given the legal implications of an admission of liability. But due to the complex and sensitive nature of human rights claims, sometimes this is part of what is required. The confidential space that mediation allows can provide for these conversations to take place and can include consideration of additional factors such as the apology, but also consideration around changes in policy and systemic behaviours. Due to the complex nature of human rights claims, there can be matters which involve public interest issues and which require precedent to be set. And it's important that these cases do go to court. But even in those cases, mediation isn't necessarily precluded. There can be a benefit in consideration of some of the additional factors of these claims through a mediated settlement. This would require expert legal advice and careful consideration with a specialist mediator. I think it's something that's always worth exploring.